Hello, everyone. My name is Lauren Antone, and I'm the Senior Marketing and Events Coordinator at MAR, as well as the producer of our free webinar series. Our webinar today it's called Errors and Omissions for a Reason. This webinar will discuss how 99.9% of E&O claims result from alleged human error. We will cover the issues that get agents and brokers into trouble, how to minimize that likelihood, and making sure your professional insurance program is up to the task of protecting your firm. After our live session, the webinar will be recorded and added to our website at marealtor.com. If you have any questions throughout this session, please type them in the bottom of the chat box on your screen, and we will hold a Q&A afterward. Our presenter today is John Torvey. John Torvey is the Vice President of Marketing and Sales at the Landy Insurance Agency of Norwood, Massachusetts. John has been in the insurance industry, focusing on the needs of business owners for over 28 years. He holds a bachelor's degree from Providence College, a master's degree from Springfield College, and is a frequent speaker and contributor to professional journals and conferences for the real estate, legal, accounting, and insurance industries. The Landy Agency is a national leader in providing professional insurance services for attorneys, real estate professionals, and accountants. John can be reached at johnt@landy.com or visit www.landy.com for more information. Now, over to John.
Good morning, Lauren, and thank you. And good morning, everyone. Thank you so much for taking part of this webinar with your busy schedules. I hope it's helpful. We'll talk a little bit about insurance today, some of the common themes around malpractice claims, as well as cybercrime, and hopefully offer some information that will be helpful not only in developing a plan to stay out of trouble, but maybe avoid some of the conflicts and issues that come up for real estate agents and brokers. And I think the information this morning will be helpful to both agents and brokers. So again, thank you for your participation. So why insurance? Because nobody's perfect. And there are a few good reasons, especially that we need to consider. Everyone asks me, it seems, am I liable? And it's really not the right question to ask because anybody can get sued. And liability happens once the lawyers get involved and the case is argued and the merits of each position are determined. And it's really the allegation that hurts. It can be an unhappy buyer or seller. It can be a lot of reasons that someone thinks that they want to sue you, and they can sue you for just about any reason that they think that they want to. So it really is the allegation, and guilt and liability is something that happens down the road. 99% of all malpractice claims result from human error, and that's a big number. The realtor community has exceptional tools to perform your professional services, and despite all of that, it's really what happens between the chair and the desk, as I like to say, that results in error and malpractice claims. And very similarly with that, 90% of all cybercrimes begin with one of us doing something wrong, so to speak, typically opening a phishing email. We'll talk a little bit about cybercrime. So it's really what we do, not necessarily the tools we have, but it's what we do with them that results in problems. So insurance demonstrates your commitment to your competency and your professionalism. You know, I'm not sure any of us would hire a doctor or a plumber or anyone else if we thought that they didn't have the courtesy to us as consumers to have their malpractice insurance in place. And one thing I should say, Lauren, is that a lot of most Massachusetts firms do carry malpractice insurance, and that's admirable. Okay, so some of the things need discussion around really what is an insurance plan, because not all real estate brokerages need all types of insurance, but all brokerages need some insurance. So what should we consider? These are the things that can help drive putting together a professional insurance program. The areas of practice. Some things that we do are less risky, and some things we do are more risky and create a greater likelihood of a lawsuit. So are we doing residential or commercial work, property management? Are we involved in other specialty market areas that may drive the likelihood of a malpractice claim? What about our type of clientele? high value properties, international work, even multi-state work can increase the likelihood of a malpractice claim. And that should be a consideration of how we determine our insurance program. What about the size of your firm? Do you have satellite offices? Do you have people working from home? The financial practices that are in place within the firm, including check writing and bill and commission payments. Is the firm doing escrow work? These things certainly increase the likelihood of a cyber attack, for example. And with satellite offices and folks working from home, there are also issues there around general liability coverage. So all of these things can help define what coverage might be needed. The real estate community is very unique compared to many other industries with the focus on in the model of independent contractors versus all employees like many other professions have. So coverage needs need to be considered for independent contractors. For example, do general liability policies and cybercrime policies cover independent contractors, or do they just cover employees? As a person looks at their insurance program or thinks about developing a program, they want to make sure that independent contractors are included in everything that they do. Risk tolerance is really what it's all about. What do you do and how do you do it? People say, how much insurance should I buy? How big is my deductible? What should I buy? A lot of it can be answered or framed at least by looking at some of the things we just talked about, high value properties, competencies around geographical areas, residential and commercial work. We know that commercial work can be a little bit riskier, and certainly property management is a very risky operation for real estate firms. So what's your risk tolerance? And ultimately it's, what helps you sleep at night? When you put your head on your pillow, are you worried about your insurance coverage? Are you worried that you don't have enough or the right thing? Or are you feeling pretty good about it? So take a look at what you do and how you do it, and that will help you determine certainly what type of insurance to evaluate what you have. So the one thing that every real estate brokerage, sure it's really close to fact, is errors and omissions insurance. And what does that do? It protects the named insured and the insureds. And those phrases and words are underlined for a reason. We'll talk about that. It protects the named insured and the insureds from allegations of malpractice, error or omission while performing a professional service. Again, something is underlined and italicized there, professional service, because those are legal and insurance terms that it's important to understand. But again, we're talking about allegations because, again, anybody can accuse you of some type of wrongdoing or error. And while policies contain very similar characteristics, they can really vary significantly from one insurance policy or carrier to another. It's not all about the price. And here's an example, just even before we get into this a little bit deeper. I mentioned property management being an area of high risk. A lot of property management claims have fair housing and discrimination at their basis, at their allegation. And if you're involved in property management, for example, you want to make sure that your E&O policy has a very high coverage built in for fair housing and discrimination. Some policies have a base of 25,000, while some policies have a base of 500,000 or a million. So again, what do you do and how do you do it? If you're doing property management, fair housing and discrimination coverage is something you definitely want to take a look at within your E&O policy. The policy may also contain coverage for disciplinary and licensing complaints, subpoena responses. There may be some coverage for data or network breach or incident response. That's not cybercrime insurance coverage, but there is some coverage often built in for a network security breach or incident that provides at least some initial assistance. Things that are typically not covered in an E&O policy, and again, this can vary significantly, or there can be portions of this coverage: bodily injury and property damage. Someone is at a showing or an open house and slips and falls on a wet floor, a railing is loose and they fall down the stairs, a window or a door is left open by the agent or the broker and there's weather damage or an animal gets in. So typically bodily injury and property damage are not covered under Arizona emissions policy. Employment practice issues are typically not covered. And that includes things like hiring and firing practices, wage discrimination, even employee theft and embezzlement. Payment disputes, disputes are not covered under E&O. Cybercrime in its true form is not covered, and that includes wire fraud and social engineering. So again, take a look at that policy, and agents really need to know this too, what's covered and what's not covered, and determine if, for example, if you're a big firm and have a big admin staff, employment practice issues can be really important. For a much smaller firm with maybe no employees, just a couple of agents, employment practices may not be an issue at all. I think that we're seeing more and more for any size firm, cybercrime is becoming a huge issue, and that's something certainly to pay attention to. So policy definitions, and I always joke that everyone, I'm sure, has read their insurance policy because they're not fun to read, and a lawyer did write them. And they contain a lot of legalese and a lot of contradictory statements, and it's important to kind of weed through that to know what it's really all about. But there are some tenets that really need to be understood and form the basis for any type of E&O policy. And one of the most important, if not the most important, is that an E&O policy is a claims-made policy. And I put in reporting period there in parentheses because the policies contain conditions about when and how to report a claim. And if in fact a claim is not reported according to the conditions of the policy, coverage can be denied. So you never want that to happen. Claims made means that the policy responds when the claim is made, not when the service was provided. And I always contrast that with an unhappy car accident. If someone gets in a fender bender today, the occurrence happened today, so it responds when the fender bender took place. On the other hand, with a real estate transaction, we may complete a transaction today, but we're not going to get sued today. It might be several years down the road that the lawsuit is made. Is made, not when the service was provided. Okay, and that leads to what we call prior acts coverage, which we're going to talk about in a moment. But earlier I mentioned named insured and who isn't insured. And this is a big deal. It seems obvious, but it is a big deal. The named insured needs to be properly reflecting the legal entity and any DBAs and fictitious names, because you don't want a lawsuit brought against your company technically insured under the policy because you have the wrong name. Who isn't insured? Again, it seems like an obvious thing, but it should be broad and reflecting the composition of your firm. And that includes your estate and your trust and your will or anything else that you may have set up to protect your family in the event that you're not around. Because one of us may unfortunately pass away and become disabled, doesn't necessarily relieve us or our estate of our liabilities. So you want to make sure that the definition of who is insured is including the words past and present. So important, because if someone leaves the firm or someone is retiring, a partnership breaks up, whatever that may be, again, it doesn't absolve anybody of their past and present liabilities. So it should include specifically owners, directors, employees, independent contractors of counsel, if the firm's big enough to have a lawyer on staff. Again, your estate, your spouse, domestic partner. What about a predecessor firm, the executors of your trust? Okay. So not all policies name all of these things, may not be even important to everyone, but it is important that your firm and how your firm is composed, and even how your family participates or may participate in that firm, or as I mentioned, on who isn't insured, so there's no gaps where a lawsuit may name someone who doesn't have coverage. Look at that, it's all written in the policy. There is in fact this section called name. You can't get that coverage from your current policy. You may need to even find a new carrier. So or retroactive date. I mentioned that earlier, that that's such an important feature of the coverage because, again, when you complete a transaction, a sale, for example, that claim is not going to be made today. It's going to be some years down the road. So a policy has a prior acts or retroactive date, and that's the date that the firm is covered back to for a professional service. Typically, that's the date that the firm is opening its doors and buys its first E&O policy and maintains continuous coverage. So here's a quick example. If your firm was formed January 1st, 2010, and bought an E&O policy January 1st, 2010, and maintained continuous coverage, all the professional services are covered back to that date, back to January 1st, 2010. So if you did a transaction in 2012, for example, and the claim was made today, November 6th, 2019, you would be covered. So it's very important to avoid any lapse in coverage, because a lapse in coverage can and almost will cause a loss of prior acts coverage, and then really everything you've done is no longer covered. However, a change of insurance companies will not be a loss of prior acts coverage. One carrier should pick up prior acts coverage with any new policy, as long, again, as there's no lapse in coverage and it's done on the renewal date of the policy. One of the things to keep in mind is that sometimes firms do change their name or change their legal entity, especially if a firm starts as a smaller firm, as a sole proprietor, and maybe gets larger and forms as an S Corp or an LLC. Okay, it's important to make sure that the work you did, for example, as a sole proprietor, is not lost, that prior acts coverage is not lost if you do switch to an S Corp, for example. It's a little tricky, but not really a big deal if you're working with an insurance agent who understands how to manage that. But remember that a change in entity requires special attention to your prior acts coverage. Couple of more policy definitions and then we'll move on. All policies have exclusions. If anyone tells you that they have comprehensive insurance and complete coverage, run away, because it doesn't exist. Insurance policies are just not comprehensive, just like all of our services, whether a real estate agent or a lawyer or a doctor, none of us provide complete and comprehensive services. So some common exclusions include, as we mentioned earlier, bodily injury, property damage, fraud, vicarious liability. In other words, someone trying to make you liable for a fringe relationship that you might have had, or a name relationship that you might have had, investment advice, accounting services, things that really fall outside the scope of a typical real estate brokerage and real estate profession. Insured versus insured. That's one I want to mention, and that means that the broker can't sue the broker can't sue the agent, or the agent can sue the broker. As we mentioned, anybody can sue anybody. You're just not going to be covered under the E&O insurance. And again, certain areas of practice can be excluded, or limitations of coverage, property management, agent-owned properties, some other things that may or may not be covered or may need to be added in to the coverage. And of course, all policies have a limit of liability, and expenses inside versus outside the limits may be important to a lot of firms. Quickly, that means if you have $1 million of coverage, if the claim expenses are inside the limit, that means that whatever it costs the insurance company to defend you and hire the attorneys and so on, that comes out of your $1 million. Claim expenses outside the limits means that $1 million of coverage remains intact to protect you for your liability insurance. So some things to look at there in terms of your coverage and understanding really how much coverage you have. So everybody hates to complete insurance applications. It's a burden, they're a hassle, I get it. But Can you view it as a resource? Can you view it as a helpful thing? If you understand what the underwriters are looking for, a few things are going to be in your benefit. First of all, you'll probably get better coverage and more options for coverage, and you'll get a better price, which is really important to save some money for good coverage, especially. So what are the underwriters looking for? All of those questions on that application are there for a reason. You know, they're looking for the traps. They're looking for the things that you're doing that increase your liability. Those things that can include dual agency, property management, commercial work, how many support staff you have versus how many agents, the type of clients you have. They're looking at all of these things and saying, okay, well, this firm is doing 50% dual agency. I mean, that's something that's going to add as a debit. It's going to cost you a few more dollars, whereas the next application that underwriter may see says this firm is doing 10% dual agency, and they're going to say, well, that's more beneficial in terms of a lower risk. We're going to apply a credit to the dual agency category. So underwriting is all a series of debits and credits, and they're looking at ways to either make your premium higher or lower, and look at those questions and understand why they're there. What are the underwriters looking for? There's a lot of layup questions on an application as well. How many CE credits you've had, what your training is, internal controls. Answer those questions in the best positive light you can, because again, those things will be to your benefit and will be a credit to your policy. In other words, lowering the premium. Again, those questions are there for a reason. And if you have a story to tell, let's say you have an attorney on a call for risk management and the contractual issues and looking over your agreements and so on, helping with complex issues. Or you have other procedures in place. Maybe your firm does a monthly agent training. Tell us, write in the margin, add a piece of paper. If you've got a good story to tell it, because it will be a beneficial underwriting characteristic and will lower your premium. So what are some of the common E&O claims that have just been the same for years and years, and what's new and what's happening now? I mentioned a lot of the claims, if not all of them, are human error, and take a look at this list. It really is all about human error. Misrepresentation around zoning, square footage, property condition. Now, zoning and square footage are black and white issues. You really can't say, well, the property is around 1,500 square feet. It is or it isn't. Okay, the zoning, it is or it isn't. We see a lot of claims around improper square footage. We see claims around misrepresentation around zoning. We see a ton of claims, believe it or not, around errors versus septic versus sewer systems, public water versus well water. These are things that you can't argue. They're black and white. And if you make a misrepresentation on that, you will be sued and you will be liable. There's just no way to win a case like that. Property condition is a little bit more subjective, but still it goes to what you're representing and really how you represent it, because over 75% of all E&O claims have to do with disclosure. What you're telling or what you're not telling the person, typically the buyer, about the property condition. Is it in a flood zone? Are there environmental hazards? Does the property have a condition or a history of flooded basements, and so on and so forth? But disclosure really drives easily 3/4 of all of the E&O claims that we see. Fair housing and discrimination are big claims typically. They're not as common. They're very common on the property management side, but we do see them, and sometimes they kind of fall into disclosure. For example, statements made around school systems and the type of neighborhood that can really get an agent into trouble. We'll talk a little bit about opinion and fact in a moment. Escrow services, money disputes are always a common form of E&O claims. We don't see foreclosures and eviction issues so much these days. We saw a ton of them, back when the market crashed roughly around 2008, 2009, where there were a lot of foreclosure properties. Agents were getting involved in evictions and were giving advice that included quasi-legal advice, quasi-financial advice about, what would happen with a mortgage, for example, around a short sale, and other eviction practices that really were improper and sometimes illegal. We're not seeing those so much now, but if the market crashes again, and we know it will because financial cycles are historical, we will get into foreclosure and eviction issues again. So something to keep in mind. Dual agency is a big and common form of E&O insurance claim because it's very hard to represent a firm or an agent who's involved in dual agency. With property management, failure to maintain the property. Again, those are historical claims. We'll see them year after year into the past and into the future. But some of the new stuff we're seeing is includes last minute change of buyer, syndicate, and funding schemes. So you think you're working with someone, and all of a sudden there's a new buyer, a new source of funds coming in at the last minute, and those can be tricky because, is there money laundering going on? Is there fraud going on? Drones are a big issue because they just lead to not only bodily injury, property damage claims. I always joke about the drone falling out of the sky and hitting me in the head, but there are issues around drones with privacy, trespassing, misrepresentation. For example, a drone can take a picture of a property, but the picture includes the beautiful woodland and lake behind it, and that picture is posted on the MLS, and everybody thinks that this house is coming with a beautiful wooded lot and a pond and so on. So misrepresentation can be a real issue around drones too. Courtesy showings and open houses are a new thing for us, maybe not so new, but I think that the lawyers are getting wise to these things, and there's more lawsuits. And what a courtesy showing is that, my firm is listing this property, and we have an open house scheduled for Sunday, and all of a sudden there's a last minute change. Maybe I can't make it. I've got a sick child or some other obligation. I can't get everybody to cover the open house from my firm. So I call my friend Lauren and I say, Lauren, can your firm or can you cover the open house for me? And Lauren's a great person. She says, sure. So she does the open house for me, and someone slips and falls. We mentioned that earlier. Well, guess who's going to get sued? Now, I'm going to get sued because I have the listing, but I should have coverage for that under my general liability policy because I have care and custody and control of that property because I have the open house. I'm the listing agent. What about Lauren? Lauren doesn't have care or custody. She's got no legal involvement with that property at all. So if she gets sued, she's got no defense. Or she has a defense, she's going to have to pay for it on her own because the E&O will not cover that, and her general liability insurance will not cover that. So be really careful with courtesy showings and who you ask to maybe manage an open house or take someone to a property for a showing. At the very least, it should be someone within your firm covered under that E&O and general liability policy. If you bring someone in totally from the outside, you're putting that person at risk for having no coverage at all. Hybrid appraisals I listed here. I know how much real estate agents and brokers love appraisals and appraisers, but I'm a big advocate for appraisers, as most people know, as well as for the real estate agents and brokers. And hybrid appraisals are something to keep in mind where a property is being assessed or appraised with information that's not being fully developed by the appraiser. So there can be issues around valuation that can come back to bite both the selling representative and the buyer's representative later on if there's an issue around value. So what are some things that we can do to avoid getting sued? First of all, disclose, don't diagnose. I would venture that most folks listening to this webinar and in practicing in general are not home inspectors, structural engineers, um, surveyors, and so on. So while we can disclose that the property has a leak in the ceiling because we can see the spot on the paint or in the ceiling, or we can disclose that the property may have a wet basement or anything else around that, we can't diagnose. Okay, we shouldn't say, well, the roof has got a little bit of leak, but I think it's just some flashing up there that needs to be repaired, or I think there's a loose shingle, or whatever that might be. Unless again you're qualified as a general contractor, a home inspector, so on and so forth, don't diagnose the problem. Let the buyer and the seller take responsibility for that, whoever it's appropriate for. And anything that you disclose should include a disclaimer that any material information that you're providing on the property should be independently verified by an expert. Okay, is that fun to tell a buyer or seller to do? No. Is it comfortable? Is it a hassle? May it slow things down? Yes. Will it keep you from being sued? Absolutely. So again, take that step, disclose, don't diagnose, and put everything in writing, including texts and conversations, and send a follow-up email. If you have a conversation with a client on the phone about something that's material to the transaction, send the email follow-up. Dear John, as per our conversation this morning regarding the leaky roof, okay, document it. If in fact you get sued, your defense attorney needs to have tools to defend you. What are those tools? It's all of the documentation that you provide and keep in your file to protect yourself and protect the parties involved. And be cautious with advice and opinion. It's kind of like I said up top about not diagnosing, but also things like, it's a great school system. It's the best school system in the area. I don't think that this property will lose value. I think it'll only gain value. Well, how can you prove that? So as a professional, especially in the real estate world, people are going to be looking for your opinion. It's a very personal type of relationship you have with your clients, but avoid advice and opinion because they're going to take it as fact. And avoid superlatives. I mentioned earlier that none of us provide a comprehensive service. None of us are the best. None of us are experts. None of us provide a complete service. So avoid saying that, including on your website and any marketing materials. And with dual agency, again, who are you representing? You can't win. You can't win that case because if you think you're representing the seller, then the buyer is going to win that lawsuit, or vice versa. It's very difficult for the defense attorneys to have a situation where there's no liability on the part of the agent or the brokerage with dual agency. As is does not relieve your duty to disclose. Maybe your property sold as is, but you still have to disclose the known facts and conditions of the property. Keep track of the people at the showings and open houses to avoid bodily injury, property damage, and theft. And I always use this example. It's a terrible example, but it really hits home where an agent, not in this state, but an agent was doing a showing. The prospective buyer came, had a friend with her. While the agent was talking to the prospective buyer, the friend started roaming around the property themselves, walked into a unfinished storage room that should have been closed or locked, fell through the floor, and broke their back. So that's an extreme example, but you got to keep track of the people in the open house, and that's a safety issue for the realtor, of course, as well. So we've got a few minutes left and we can talk about cybercrime. This is absolutely the fastest growing businesses in general. Real estate professionals are very attractive to cyber criminals. You've got an IT handicap, typically small offices. You're good at selling real estate, property management, and so on. You're probably not so good at managing a secure network. Think about what you have. You have really information that is attractive to the cyber criminal: names, date of births, account numbers, and driver's license numbers, and so on. And I know that the realtors always say to me, but I don't have that information. I don't want that information. I don't ask for that information. And guess what? They send it to you anyway. The client will send it to you anyway. You'll end up with somebody's W-2, mortgage disclosures, and so on and so forth. So you're right for confidential information, and especially if you're holding escrow or IOLTA accounts where the cyber criminal wants to get at that money. It's a social and personal profession that you're in. You're working and you're communicating all the time versus someone with a more distant relationship. You're using social media, phones, iPads to communicate and store data. It just makes the whole thing very risky. 90% of all computer crimes begin with someone opening a phishing email. Okay, so we get an email that we're not sure about, or looks okay, or we're so busy we don't bother, and we click on that link and we click on that attachment, and out of all of those emails, those phishing emails that we get, 30% of them we open. Human error. We actually click on those links in those emails, and 12% of those targeted clicks on links are, again, things that we do. And I can tell you that professional association recently had the whole members hacked, and all of a sudden the members are seeing their emails being stolen, phishing emails. So it's a real thing, and again, it's something that human beings can in fact stop and get better at. So training is very important. Recognizing how cyber criminals use these phishing emails and recognizing what they look like can go a long way to increasing your cyber security. Wire transfer fraud and social engineering are variations on the same thing. Basically, the bad guys want to get your money, want to get at that money, and it even could include a payroll or a commission account. Recognize that Verizon, this is another Verizon statistic, that once a network is hacked, the bad actor is in the network for an average of 100 days, over 100 days, before they take any action. So someone's in your network and basically watching everything you do for 3 or 4 or 5 months. They're getting to know your habits, who you talk to, how you talk to them, when the transactions are going to take place. You for a long time till they think it's the right time to act. And sometimes they go in and they steal the money themselves. That's called wire transfer fraud. And sometimes they manipulate us into sending the money with false accounts, false routing numbers, even fake PO boxes. And people say, well, I'm not wiring any money, I'm going to mail it. Well, so the bad actor gives you a PO box that's going to them instead of to the bank, for example. We're seeing fake 800 numbers. Sure, you can verify this transaction. Please call 800 whatever. And that's just a number that's set up, again, by the cyber criminal. So they're very tricky, they're very sophisticated, and they want what you have. So with cybercrime insurance, there's some things to consider. Over $400 billion is the estimated annual cost of wire fraud. We're not talking about data breach and ransomware. That's just wire fraud, somebody stealing money. Over $6 trillion is the estimated global cost of cybercrime. That's certainly a lot of money. 68% of funds lost to cybercrime are unrecoverable. That money goes so quickly, it's just almost impossible to get back. We know data breaches are increasing. 43% of attacks target small businesses. And let's think about that and how you work. That, just a few years ago, 10 billion devices were connected to the internet. By next year, over 34 billion devices will be connected. And that includes things like your thermostat and refrigerator and so on. It's really scary to think that your thermostat may be hacking you within your own office or your house, but it's entirely possible, and something that is happening more and more. So it's a scary world regarding our internet security. Cybercrime insurance should include these things. It should include protection for data theft and compromise, include coverage for ransomware, In other words, if your system is hacked and held for ransom and shut down until you provide the cyber criminal with $5,000 or whatever they may be asking for to release your system. And we've been mentioning theft of funds. There's necessary compliance with state laws. Massachusetts has very strict laws around protection of consumer data and information, including names, driver's license numbers, socials, account numbers, and so on. And if you're hacked and not compliant with Massachusetts state law, for example, they can fine you on a per record basis. Not one fine, but they can fine you for every record that's been violated. First and third party liability coverage basically means that if somebody wants to sue you, you have protection and defense against the lawsuit. You may be required to provide notification and credit monitoring to the parties that are affected. So you want to make sure that that insurance policy covers those costs. If you're hacked, it's a small world we live in. You know, there could be public relations nightmares, reputational harm. The insurance policy should provide assistance to get your reputation and your public relations back to where it was prior to the hack. You need to restore your data and you need to get your system back online. So coverage needs to be there for that. If there's data extortion, again, there's a cost of not only the money being stolen, but loss of income perhaps, and other expenses related to that. I didn't know this until I started getting into this cybercrime insurance a few years ago, but the payment card industry can fine you on their own. So if your firm accepts credit cards, believe it or not, the credit card industry can fine you and invoke penalties for a cyber breach. Communications and media liability needs to be covered, so any hacks and communication failures related to social networking and so on, you want to make sure there's coverage there. And again, the wire fraud and the social engineering where the money is actually being stolen. Not all policies cover wire fraud or social engineering. If you're thinking about purchasing cybercrime or you want to assess the insurance that you have currently, really talk to someone and break it down piece by piece. What is your firm doing? What's the risk? What data do they store? How is your network managed? What are your IT controls? Are you managing other people's funds? Do you have escrow accounts? And break that down to make sure you have the right kind of coverage. Some things to do to minimize the risk as we wrap this up here. Really take care with social media postings, not just posting information that can be deemed as inaccurate or a violation of someone's privacy. Please don't put on LinkedIn, congratulations to John and Mary Smith who just bought their house at 39 Main Street. You know, that may be public knowledge, but you don't need to make it worse and, you know, risk their privacy as well. You want to develop protocol for all of your communication devices, enable lock screens, change your IDs and your PIN numbers very frequently. You know, a lot of this stuff can be managed with training within the office and broker to agent. A lot of brokerages develop really strong protocols, network securities, and procedures for how communication devices, computers, procedures should be handled. And then unfortunately, a lot of agents go out and do none of this. They'll use Google accounts or they'll set up their own websites and so on that have none of the security protocols that the brokerage sets up. So I think it's important to establish procedures and ensure that everyone follows them. Don't save passwords, use a password manager. There are many of them. They're easy to use. Most of them are free, and it will take the concern away from using multiple passwords or even trying to remember all of the passwords. Avoid using public Wi-Fi whenever possible because that's a guaranteed entrance into your network. Check the permissions on all of your devices. This one I learned from an FBI agent about not keeping multiple windows open. For example, let's say you're at Starbucks and your looking at your Facebook page or your LinkedIn page, and you decide, hey, I should pay that bill, or yeah, I just got an email from the client, they want to make an offer, let me deal with this. And now you open up a personal banking account or something that's more confidential, but you leave that Facebook page open. Well, if Facebook is infiltrated, which there's a really good chance it is, now that bad actor is seeing everything that you have on your phone open at that time, you have on your laptop open at that time. So before you jump into your banking website, start transferring money, dealing with confidential information, close everything else. Make sure all the other things are closed. So y'all can read the rest of this. It's really important. I don't want to skip through it, but I don't want to have to read everything when I know we're a little bit pressed for time as well. Um, Network security is so important. It's, again, something that's happening every day, and the real estate community is very vulnerable to this. So do what you can to minimize it. I'm happy to answer, again, more questions in detail. I'll get into some things that we certainly can't get into within the scope of this webinar. So thank you all. I think we might have some questions. Okay.
So thank you so much, John, for that. And thank you, everyone, for sticking with us, even though we had some technical errors here. But if you have any questions, now is the time to write them in your chat box. It looks like we already have a few questions already. But first, I'm going to go back to when we did have that outage. We had a couple people ask if you can repeat the part about the definitions and the timing of the claim.
Sure, certainly. Okay, two different things, though they play into each other, certainly. First of all, the claim and the timing of the claims. The policy is a claims-made policy, so the coverage leaps into effect when the claim is made. If you provide a professional service today, you won't be sued today. It will be some years down the line, typically, when that property is called into question. It could be a refinance, it could be a sale, it could be a divorce, a estate settlement, whatever. So whatever you do today is really not going to be questioned in most cases until some point down the road. So the policy responds when the claim is made and not when the and it has to fall within the prior act's policy. And the prior act's date is the date that you're covered for, going back to typically when the firm was opened and when the first E&O policy was purchased and remained in force. So the example I used, if we got cut off at that point, was your firm opens January 1st, 2010. You bought your E&O policy that day, and you maintain continuous insurance, and you sold the property in 2012, and somebody wants to sue you today because of something. They could say, well, gee, you got the zoning was wrong. I thought I could open up a home business, and you're telling me I can't. Or, whatever it might be, they're going to sue you today. So the claim happens today, and your policy jumps into action today. The reporting part of it means that the policy requires you to report a potential claim within the framework of the language of the policy. In most cases, it needs to be reported as soon as you become aware of it and within the policy period. So here's an example I use all the time. And actually a couple of examples, they're a little bit different. Let's say your policy runs January 1st to December 31st. And you're taking a family vacation, you decide to go to Mexico for Christmas and over the New Year's, and while you're away, or even before you go, you get notice of a claim, and it sounds like a hassle, somebody's complaining about a leaky roof or whatever, I can deal with this when I get back. So you go on your vacation and you come back. In the meantime, your policy renewed, because at least you did that before you went on vacation. And then you notify the insurance company on January 10th of a claim you received December 10th, let's say, in the previous policy period. And the insurance company can say, well, you received notice of this claim in the previous policy year, you're reporting it after that. we're going to deny coverage. Now, that doesn't happen that often, and insurance companies aren't typically that much of that mean, so to speak. But, there's a real risk there. And the real risk is not so much a few days, it's 6 months later. And another example, and this is a real life example of reporting the claim during the proper period. A brokerage, this took place out in California, a brokerage sold a property. It was a agent owned property. They bought the property to flip. They did some repairs. They sold the property under the firm's name, and the buyer complained of a roof problem. And the broker said, "Okay, well, I'll fix it. No big deal. I'll fix the problem." Then the buyer complained about something else, and the broker fixed that. And then the buyer kept complaining, and all of a sudden, a $5,000 repair turned into, something that was costing the broker close to $100,000. And at that point, he turned it over to the insurance company. Well, two things happened. One, he did not report the claim when he became aware of it. And he reported the claim months and months after the policy had renewed. So the insurance company could have totally declined coverage for that. But they picked up coverage. They started to defend him. It turned into a real mess. The $5,000 leaky roof turned into an $800,000 claim because the buyer just was relentless and wouldn't let the broker off the hook. And at that point, the insurance company said, "Hey, we spent $800,000 on this $5,000 leaky roof. We're done." And at that point, the insurance company took advantage of its legal right to get off the claim. So it's really important to, if you have any idea that there may be a claim, to discuss that with your insurance representative to see if it should be reported. And again, to report that claim, a potential claim, within the policy period.
Sounds good. Great. So we'll go to our next question here. It says, what if you offer dual agency because you're a small firm, but it rarely happens that you represent both sides in the same transaction?
Okay, well, I may be showing my ignorance here, because I thought if you're dual agency, you are representing both sides in the transaction. So I may beg off on that and try to get a better explanation of my understanding. Dual agency to me means that your firm is representing the buyer and the seller in some form.
We'll go to the next one then. Melanie, if you want to expand on that question, I'll be sure to see it at the bottom. Are there any additional protection or things to do if you're a small firm and sometimes do not have another option other than dual?
Well, I think one of the things that you certainly can do is make sure, again, in writing to both parties, that you are representing both sides of the transaction, and that any representation you make to either side will be based on fact and available information, that each party should hire independent bodies, so to speak, whether it's a general contractor, an electrical contractor, whatever it may be, to verify any conditions around the property. Whatever you can do to show that you're not favoring either side, and whatever communications that you have with one side shared with the other. Of course, we're not talking about financial information and that kind of thing, but if one side is discussing a property condition or a condition of sale, that information is shared equally with all sides, to again show that you're not in avoiding any evidence of taking side or favoritism in the transaction.
Okay. We have another question about can you repeat the disclosure? You said something about any material information, something.
Yes, I think what we're referring to here is my statement that says disclose but don't diagnose. We can disclose that the roof leaks, but we can't diagnose it, again, unless we're a roofing expert. So we want to avoid opinions and trying to be helpful with helpful advice that says, well, the roof is leaking because I think there's a loose shingle and it'll only cost you maybe a few $100s to fix. Those are things that you can't verify and can't defend because you're not an expert in the roofing area or in construction. So we wanted to be able to disclose things and not diagnose them, and anything that is of issue or question around the property, that you put in writing that the property or the condition, the alleged defect, should be inspected and verified by an independent source. And that can even include things, I mentioned hybrid appraisals, where maybe the appraiser is not measuring the property, and a person, whoever is doing the measurement, may say that the house is 2,100 square feet, and MLS has the property at 2,200 square feet, for example. So you have that discrepancy. At that point, you may, depending upon the negotiation, have the buyer or the seller independently have someone measure that property. So it's important to get factual information correct, have it verified by an expert in that field, and not take the leap of judgment or faith, and certainly keep all of the guesswork out of it.
We have a question about what about agents who refuse to use office email, which has all protections in place, and instead use their Gmail or AOL account?
I assume that this question is from a broker. You know, one of the beauties, as well as one of the difficulties in the real estate community, is the independent contractor status of agents, and trying to maintain sound office and business protocols while not infringing upon the IC status. My experience and what I've heard from lawyers and other professionals around the country is that the broker can in fact enforce network security protocols in the agency. And the first step in that is having that as part of the broker agent agreement or independent contractor agreement that goes beyond some of the basics within the state form, for example, and talks about things like network security, that the agent will in fact follow the protocols and securities set up by the brokerage, including no independent email addresses and so on, and violation of that can be cause for termination. Now, I'm not a lawyer and I'm not giving legal advice here, so that's my CYA a little bit, quite frankly. But I've been around this long enough to know that view is upheld and has been upheld in many circumstances. And if you have access to an attorney or one of the attorneys within MAR, for example, can help you craft out language, I think it's totally appropriate to put that in the broker agent agreement, and again, have it cause for some type of repercussion or termination if it's not followed.
So we have a hypothetical here. So let's say you dissolved your firm and you no longer have a need for E&O coverage. Are you saying you need to retain E&O coverage in perpetuity to ensure prior acts are covered?
Yeah, that's a great question, and the basic answer to that is yes, though not necessarily maintained forever. The policies have a feature called extended reporting period. We call that on the street tail coverage. That's how most people refer to it. As I mentioned, just because your firm is dissolved, or you might retire, leave the business, become ill, whatever reason for no longer being involved in the real estate world, doesn't relieve you or potentially your estate or spouse of liability or responsibility. So the policies offer what's called an extended reporting period coverage, and that allows you to obtain coverage if your firm shuts down, for example, or you retire. It allows you to obtain coverage into the future for your prior acts, and that sounds a little difficult or contradictory, but what you're doing is you're protecting your prior acts for some years into the future. How long you want to do that, how long you need to do that, really is a function of the business. People will always point to the statute of limitations being a kind of a line of demarcation about how long you need to hold on to files or can be sued for. But that's not a hard and fast line either, because there's a lot of legal issues around what the statute of limitations really means or when it can be enacted. But in order to have coverage, this is the bottom line answer to the question, I think. In order to have coverage under your E&O policy, even if your firm is dissolved, you need to have a coverage in force when the claim is made. Going back to that claims made thing. So if you're closing your firm, you're retiring, you really should consider purchasing an extended reporting period. A lot of the good policies and the better carriers will offer free coverage, for example, for retirement, death, or disability. There are conditions around that. For example, you may need to attain a certain age or be with a carrier for so many years before they'll give you free retirement coverage, for example. But take a look at that. If you're close to retiring, for example, maybe a year or two out, take a look at that insurance policy and see what the retirement provisions are, because it may not be a time to go shopping for E&O insurance. It's not a good time to go and see if you can save $100 when, if you stay with that carrier until you retire, you're going to get free coverage for the rest of your life. So you have to have coverage in force, even if you close your shop, even if you retire, in order for a claim to be covered.
And you might have just answered this, but is there a statute of limitations period on E&O?
Statute of limitations vary by state. They can vary by accusation, and they can also be argued in terms of when that statute of limitations actually starts the clock, so to speak. So the statute of limitations could begin when you completed that transaction. In some cases, the statute of limitations can begin when the alleged error was discovered. So you may have sold that property 5 years ago, but if someone discovers some type of error today and can make the legal argument that discovery begins today, that statute of limitations starts to click today, not 5 years ago. So it's a complex legal issue. It can be argued in a lot of different ways. It can vary by state, and it can vary by accusation of what you did or alleged to have done wrong.
Great. And it looks like that's just about all the time that we have here. I can answer 2 other questions here. It says, does the training offer CEs? This webinar does not offer CEs. None of our webinars offer CEs. However, if you are looking to get CEs, head to marealtor.com, click on members and then education, and head to our learning libraries where you can take a bunch of different CEs there. And lastly, we have an inquiry for the checklist on your presentation. Is it all right if I send them that last cybersecurity checklist?
Oh, sure. Sure. You
Sure.
can send the whole thing if they'd like.
Okay.
Absolutely.
Okay. So I have everyone's emails on here. So I will go ahead and send you that checklist. Okay, that looks like that's all the questions for today. As a reminder to everyone, this webinar has been recorded and will be available to view in the next few days on our website at marealtor.com. Thank you so much, John, for your presentation, and thank you to everyone for joining today. I know that there's a couple questions I wasn't able to get to, but please reach out to John at johnt@landy.com for more information, and we hope to see you next time.
Thank you. Thanks for having me, and have a great day, everyone.